Oh, yay, oh, yay, oh, yay. The Honorable Court of Appeals for the 11th District of Texas is now in session.
Thank you, Mrs. Williamson. Mr. Boone and Mr. Hall, I'm going to tell you right now, we have had technological fits all morning. So if you'll bear with us, hopefully we could get through your argument. We had problems at the start of the last one, and then right at the very end with 18 seconds left. Turns out that's the absolute worst time to have a problem, because the guy didn't realize that we were frozen, and so he was just going away at it. But anyway, rock along with us, be patient. It's our privilege to be here today to hear arguments with a full court. I don't know how they're arranged on your screen, but I'm relieved and welcomed to have Stacy Trotter from Odessa to join the court, and Bruce Williams from Midland here to join the court. We're the now 3 active judges. The first time in 29 months we've had 3 active judges on the court. So we're ready to proceed. We'll call our next case 11-19-371 West Texas Landscape. Is it Meneses? Meneses. Okay. Good deal. Yes. All right. Mr. Boone, are you ready to proceed?
Ready, Your Honor.
You may.
May it please this honorable court. My name is Billy Boone. I represent West Texas Landscape, doing business as Taylor Landscape. This case is a written contract case. It's a little unique in a couple of the issues in it. One is this has as many photographs as I've ever seen of the completed work. We generally do not have those. And this one, there's about 22 pictures of the completed work, which kind of comes in play on the substantial compliance or completion issue. Secondly, a little bit of background. There was a written contract signed in May of 2012. Goods, the materials, the supplies necessary to build this pool, and landscaping and rocks and trees, and started being delivered in May of 2012. It was completed in November 2012. Then from that point till for about 8 to 9 months, there was at least 5 different punch lists that were done. The final invoice was sent out in April 2013. In 2015, December 2015, Mr. Meneses hired an expert to review his pool. They gave notice of deficiencies April 19, 2016. Suit was filed by Taylor Landscape sometime later. As a written contract case, I think the overriding issue in this matter is going to be the breach and if there was a modification, so to prevent the breach in this case. Mr. Meneses, and it's in the brief, he had testified that he didn't make, let me back up. In this contract, there was a schedule of payments that required when payments were due. It was undisputed that in June, Mr. Meneses missed or did not pay one of those scheduled payments. He also didn't pay the final payment. And the testimony is that, like one of the questions I'd ask him, and it's referenced and set forth in the brief, you've been in breach of the contract since you missed your 10% payment prior to gunite. I did miss that payment, yes, sir. When you missed the payment, there was a breach of the contract, correct? Yes, sir. So we have a breach that's admitted. Those were.
Hey, counsel, isn't the issue whether there's a material breach, and aren't there a series of considerations that the fact finder can look at to determine whether the breach was material?
Materiality does enter into it, primarily under the Mustang Pipeline case, where yes, you are excused from performance. We really don't have an excuse of performance in this case, because despite that, And part of it has to do with the timing of a construction job. You just keep right on going. So we did not take the position that we are prevented. We can withdraw. We don't have to do any more work. So I don't think it's a true, is there a material breach? Yes, I believe, and we'll get into that in a minute. But under the Dobbins versus Redden, if you breach the contract, you can't sue for damages on it if you're in breach. And that
If it's
doesn't,
material breach, right?
well, Dobbins doesn't say material breach. Now, I think an insignificant breach, there might be an argument. I hadn't seen cases on that, but the Dobbins was very clear. If you're in breach of your contract, and this case was $8,800 he was supposed to pay, then he can't sue for damages on that. And Mustang then took that further and added materiality to it, in that if you're excused from performance. So I don't think materiality, while I think it's present in this case, that's not the sole derivative of this. There was a breach, an admission of the breach. And to me, the crux of the issue is, was there a proper modification of that agreement? And our assertion is that it's not. We do have a written agreement. That agreement was signed by both parties and delivered. They didn't make the payments. Mr. Meneses at trial, even though modification was not pled as an affirmative defense, contended that the agreement had been modified. So he only had to pay when he was told to. There's a dispute in the evidence, and I understand we lost. So I understand the disputes ruled against us, but they had argued at trial mutual assent, which is basically a modification. And the trial court, and we'll get to the findings here in a minute because that's a little unusual, but the court held that he had not breached the agreement. So, I mean, we have definite terms. We can't rewrite the contract. So there had to be a modification. We're left with that convincingly. That had to be the case. Now, the problem, when they started this mutual assent or modification, I raised first-time statute of frauds. I had not pled statute of frauds. There'd been no modification pled. So we have modification and statute of frauds tried to the court. I've asserted that this case, because of the vast volume of goods, trees, plants, all this other stuff, that this falls under the statute of frauds. And I think in there I'd broke out $35,000 of $88,000 was labor, and the rest was materials. So we'd raised the defense under the statute of frauds. Secondly, and I think this is what's more tellingly, you can modify a contract provided you don't alter the obligations of the underlying contract. If you are, then you're required to have a meeting of the minds and then also have consideration. And I cited the White versus Hanson or Harrison case on that. That's pretty much standard Texas law. Further, and in this case, there is absolutely not one iota of evidence about the consideration. There's really not anything about the meeting of the minds. And I understand that's more of a nebulous finding for the trial court. But there is, again, under Rilek and Dupree in those cases, and White, there must be consideration. And there is not a scintilla of evidence that there was any consideration for the modification of this contract to relieve Mr. Meneses of his breach.
Okay, let's go back to the statute of frauds.
Yes,
Statute of frauds applies if the essence of the contract is that it was goods, not services, right?
Yes,
Okay.
that is correct. And then if that applies, then you can only modify it in writing signed by the parties to be bound.
Right. And have you looked at a case called Propulsion Technology, Inc. versus Atwood? It's a Fifth Circuit 2004 case determining that the building of a pool is a service, not a good? And if you have, can you distinguish that case for me?
Your Honor, I have not seen that case.
Okay.
The cases I'd looked at had broken out, which is the way I did it in my brief. They broke out what are goods, what are services. You know, if it is a service, then you're providing the material and things like that. It's not a sale of goods. Here, I broke it out in the contract. The way the contract was put out, there was $88,000 contract, 35,000 was to dig the pool and the labor in doing the contract. That to me is the services. The other 53,000 are these trees and all of these other items that are planted around there, the rocks, all of the other things, the brick pavers, all of those. So I separated them out, which is what, from the cases I'd looked at, seemed what they tried to do is now, and I would agree with the court if labor in this case would have been $55,000 and $33,000 in items that were sold that were identifiable, which is what the statute says in the old cases. If they are identifiable items that you can attribute to this project, then those are goods. And in this case, it's just swapped like 35 and 53. 53 of being the items, the high dollar palm trees and things like that. So that's why I was alleging that it was covered by the statute of frauds. But I have not looked at at that Fifth Circuit case. I have not.
All right.
I would still challenge it in that here we do have, because of the high end of this project, the cost of the materials, the items, was way substantially more than the labor or the services to dig the holes, to put them in, to dig the pool, things like that. And that's why we were asserting the statute of frauds.
Okay, I understand your argument. I anticipate the homeowner's argument is going to be the essence was building a pool. We wouldn't have asked for these trees and pavers and all these things except as an amenity to the pool that we want built. And what would your response be to that? Help me.
My response to that is when you look at a contract that has a combination of these items and the services.
Yes, sir.
Would they have been happy with a pool that had no pavers, no trees, none of the other attributes? You know, if they're trying to say that, then we certainly overbuilt it. And the cases that I'd cited in the brief and that I had reviewed, you look at when you look at the essence, what is the totality of it? You know, what is the labor? You know, if I'm going to erect a building, you know, most buildings, your labor cost is usually more than your construction materials. In this case, because of the high-end nature of what was done, here the materials, the items, was greatly more than the labor cost.
Okay. I'm sorry I got you off. You were talking about not having pled the statute of frauds. How do we now consider it as an appellate court?
It was tried by consent, Your Honor. And in fact, I'd referenced in there in the discussion with the court, one of the dialogues we had when it first came up, that we had reached, he said we had agreed or we'd modified. And at that point, I'd objected under the statute of frauds. And there's a back and forth with the court concerning whether there was a statute of frauds issue or a modified or oral agreement. Okay. And so it was tried, expressed to the court. It was discussed between the court and I, and we finished up the case trying that. So it was tried by consent. Okay.
And trial by consent, do you have a trial by consent with a discussion with the court, or do you have a trial by consent with evidence that is offered that is not objected to?
You have a trial by consent by informing the court of the issue, discussing the issues, making objections based on that, and arguing that. Okay. There was evidence that we got the written contract where there was no written agreement modifying the same.
Okay.
So
Did you
that's
ask
how
for
we
a
get-
did you ask for a trial amendment of your pleading, or did you, after the fact, did you amend your pleading so that we have something before us that says your argument conforms to your pleadings?
There was no trial amendment asked or filed after the fact, Your Honor.
All right.
Getting back to the breach and here's on the modification of it. A modification does require, it's changing the terms of the agreement, which is clear. And if there is a modification, it requires consideration. And there was never any evidence of any consideration for that modification whatsoever. And as such, under the cases, the modification can't stand. Again, there's no evidence of that. Because essentially what the court did, we got in there and the contract was rewritten because there was no consideration. And I know there's a dispute on whether or not there was a mutual assent or meeting of the minds, but certainly the second element, and it's required, is the consideration. And Jeff, one of my, Justice Williams, I'm a little concerned. I don't see the clock today.
Okay.
So,
You've got 5 minutes.
I have 5 minutes.
Yes, sir.
Okay. All right.
Do you want me to advise you when you got 1 minute left?
Yes, sir.
Okay, I'll do that.
I would appreciate that. But yeah, it's the materiality of the breach also comes in, and you know, I had raised that. It's, you know, to the extent, you know, you look at the 5 factors under Mustang Pipeline. Was Taylor deprived of the benefit that he reasonably expected? Yeah, he's supposed to get paid, didn't get paid. Can the injured party be adequately compensated? Well, you know, he wasn't. He had to file a lawsuit. So I think that factors in there. And, you know, will Meneses suffer a forfeiture? No, he got the goods. He got everything and didn't have to pay. And the likelihood of Meneses to cure his favor, that's factor 4. Will he cure his breach? Well, he certainly hasn't up to this point. So, you know, I think factor 4 is there. And was the only issue, and from reading Mustang and the subsequent conditions, I think these are factors that are weighed. There's not really a checkoff. This is what a court looks at. And the totality of the circumstances, here are 5 things, but it doesn't say you must have this, you must have this, you must have this, you must have this. You
Are those
look at
5 factors exclusive, or could there be additional factors?
There could be additional factors. Now,
okay.
Mustang Pipeline and the subsequent, and it's based on the restatement, but they look at other things too. But those are kind of the core issues that they look at in determining whether or not to determine if this is a material breach or not. Okay. And what, you know, the last one was Meneses acting under standards of good faith? And I think all those factors are in favor that it was in fact a material breach. I would again re-urge that under Dobbins, if you have a breach, $8,800 payment and you don't make it, that's not insignificant. You know, there is a breach. He's supposed to make a payment and he did not. And on that, lastly, let me touch briefly on substantial performance. We had alleged that we had performed. Again, the testimony was there that we went back time and time again. In this case, there's like 22 pictures of the pool. So we're not left with just testimony. We have what the pool looks like. Pool looked, one of the items was there was a complaint about 2 palm trees that died. We have pictures over a year later that we were out there doing some touch-up work and the trees are thriving. Both sides say it's a 1-year warranty. So those trees were there. And so this is somewhat unique. I don't think anybody can look at those photographs and say there was not substantial performance or substantial completion of that pool.
Okay, is substantial performance, is there a fact issue there? And is the judge the fact finder that resolves that?
Is substantial performance generally a fact issue? Yes. I think the photographic evidence, now Mr. Meneses testified all these things were wrong the whole time. Some of these things couldn't have been, like the pool return, for instance. He didn't know about that. His expert suggested getting another pool return. Well, that's one of his complaints. Well, he didn't know about that, didn't know it existed till December 2015. Now, what he got was in compliance with the agreement. Even Mr. Meneses said, I got everything in the agreement except one spot anchor, okay?
Yeah, you got 1 minute left, but then you'll have an opportunity.
Your Honor, and let me brief. In this case, there's a little bit weird. And after the judgment, there was notice of appeal. There was a request for findings of fact. The court did, within about 10 days, thereabouts, sent out findings of fact to lawyers and say, if you need anything else, court will consider it. Those never got filed.
Right.
I dropped the ball. You know, the fault is with me. I didn't file the notice. I assumed it had been. There's some other issues there, but it's not really important. You know, I did not do that, and I will fall on my sword for that. When I noticed it, I filed a notice, filed a supplemental record, and filed those of record. And the question comes down to, we have the Kendrick case out of this court and the Miller case, whether they go in, were these findings of the court, should they be considered findings of the court? My view is that they should. Here's something that the court prepared and sent it out to the lawyers for review. And do you need anything additional? And I think that is the intent of the rule, is that we have some guidance as to how did the court render this decision. And without, if we don't have that, then you know, we've certainly been harmed. And my inadvertence, I would ask that the court excuse that and not get us waiving on that. Now, even if I'd never asked for those, we still have the legal sufficiency and factual sufficiency issues, because we do have a court record, the court reporter's record, and all the exhibits.
Right.
So with that.
Thank you, Mr. Boone. You're out of time. Mr. Hall, are you ready to proceed?
Yes, Your Honor. Thank you. May it please the court. Your Honor, I wanted to generally touch on a couple of things, not only that Mr. Boone has said today, but also in his reply brief. Mr. Boone states that it's on page 19 of his reply brief, there's no evidence of any defect in workmanship during the 1-year period of warranty. And it goes on to say there's not even a scintilla of evidence to that. I wanted to direct the court's attention to Reporter's Record, Volume 5, pages 70 through 75. And Mr. Meneses testifies in that section of the record that, in fact, he did notify the appellant of multiple issues in January of 2013, and I believe in one case in December of 2012. So I just wanted to clarify that, the record on that. In fact, the court was justified in finding there was a scintilla of evidence, because there was. Mr. Meneses himself testified about notifying the appellant of those issues. Also, for maybe limiting the issues, Mr. Boone's briefs and an argument today continually talk about these palm trees. Of course, we dispute that the findings of fact and conclusions of law were timely filed in this matter, or in fact ever completed by Judge Harrison. That being said, assuming arguendo, the court considers those to have been timely filed, Judge Harrison lays out a lot of the damages sustained by Mr. Meneses. The palm trees are not in there. So I just wanted to clarify that the court, it's indicative of the court maybe agreeing that those didn't happen within 1 year, or that they certainly no damages were warranted to Mr. Meneses on that. With regard to the findings of fact and conclusions of law, it is undisputed that Judge Harrison never signed those. Judge Harrison never filed those. He sent out what he described in an email as a draft of those findings. And in fact, both Mr. Boone and myself asked if there were changes that should be made to it. That does not indicate a final document in either regard. And
Okay, counsel, for a minute, let's assume there are no findings of fact or conclusions of law. How does that affect the appellant's case?
It affects the appellant's case in primarily they would not have briefed every cause of action, namely breach of warranty that was pled and we believe proved in the matter. Their briefs simply do not discuss that, and so I believe that would be the effect of that. I think also the standard is slightly different in that every inference. I think the inferences all go our way this time, but the specific language I believe is excuse me. That I'm sorry, Your Honor. And
was there a finding of fact or conclusion of law that went against you that you would say, oh, we don't like that?
No, Your Honor. Except that we would like the breach of warranty to have been in there, and it wasn't. That's the only thing that comes to mind. I guess we did argue about the palm trees and did ask for that relief. It wasn't granted, so that would be another issue, and they were expensive, but we haven't appealed that decision that those weren't included in there, and we're not asking the court to consider that here today, but those would be some distinctions, Your Honor.
Okay, but yeah, the appellant still has a full record, and all of the issues that he's brought up would still be addressable by the court based on the judgment, correct?
Based on the judgment, I think the issues he has raised, he would have still been able to do that regardless. However, I think it does change with regards to issues he has not raised, Your Honor, if that makes sense. Specifically, the breach of warranty, there is no appeal on that issue.
Okay.
It's still a sufficiency review if there's an absence of findings, correct?
I believe that's correct, Your Honor. In fact, yeah, I think either way, the court is required to make inferences in favor of Judge Harrison's findings in this matter to support the judgment. And I think there's a lot of evidence that supports the judgment. In fact, contrary to, as I say, what the appellant has said, these issues were present very early on, certainly within the first year, and Mr. Meneses was clear that those items were never fixed by the appellant. And just on one issue, Mr. Boone discussed that in 2016, we sent a kind of notice of defects. There's also testimony which we cited in our brief. Mr. Meneses stated that until he received an invoice in 2015, he assumed that they had abandoned the job. And when he received that invoice in 2015, that's when he retained me, and that's when letters started going back and forth between counsel.
Okay, here's the question on that letter. Your client missed the gunite payment of $8,000. Did the letter of April 19, 2016 include that amount in the demand, allowing you to pay now instead of pay later that number?
No, I don't believe so, Your Honor. I'd have to look at the letter. I think a lot of what it did was, and certainly the judgment does give the appellant credit for the $8,800 payment that was missed, and it's uncontroverted it was missed. Mr. Boone did mention, but we've cited numerous instances in our brief where Mr. Meneses and I believe Mr. Taylor, the owner of the appellant, as well as his expert, Mr. Robbins, they would notify Mr. Meneses anytime a payment was due, and he paid all of those that occurred. I believe it's uncontroverted. Every payment that was requested, and he was notified of until the final payment, which he withheld. He paid those when he was notified. And when we're talking about a meeting of the minds or mutual assent, that's what the brief is really focusing on there. And that's our position, is as far as when payment was due, and there's other bases which I'll get to for Mr. Meneses to withhold those payments. But when those payments were, and by the way, Mr. Boone, it's uncontroverted that the appellant continued to work on the pool and landscaping, the project, let's say, until 2014.
What's the legal effect of that, in your opinion?
The legal effect is under the Mustang Pipeline progeny, that in continuing to perform under the contract, in other words, continuing to work, that changes the analysis under Mustang Pipeline. Assuming there was material breach that wasn't excused at that time when the prior to gunite payment was missed, even though it wasn't notified, had the appellant stopped work at that point, then there would be different arguments about what happened thereafter. They continued to work, as Mr. Boone just told the court, came back multiple times, which is, of course, because Mr. Meneses asked them to, because he was never satisfied with the work that was done, as the trial court found that he was justified in doing. So,
is there evidence of other oral modifications of the contract? If there are, tell me what they are.
I believe there's only one other one, Your Honor, and that is about this Diamond Bright Quartz that is listed in the contract for $2,500. There is evidence, contrary to the appellant's statements, that the appellant and Mr. Meneses agreed. Mr. Meneses had a friend named Rodney Foster who testified at trial. Mr. Meneses testified that the appellant agreed that if Mr. Foster signed a contract with the appellant for a pool construction job, which did happen, that $2,500 payment would be waived. That's an oral modification. There is nothing in writing to that effect, but that is the testimony, and that is what, assuming the findings of fact are considered by the court, that is the finding that Judge Harrison made. So in terms of under Mustang Pipeline, even if there was a material breach, and I'm talking here about the New York Party Shuttle case. It's a First Circuit Houston case that we cited in our brief, as well as the Richardson case, Richardson versus McNeese, Dallas case. And to quote from there, if the non-breaching party, and it's progeny of Mustang Pipeline, and cites that, if the non-breaching party elects to treat the contract as continuing and insists the party in default continue performance, the previous breach constitutes no excuse for non-performance on the part of the party not in default, and the contract continues in force for the benefit of both parties. That's extremely important. As Mr. Boone said, they were, up until this trial and today, they were continuing to try to collect the money. They kept coming back to the property, at least in 2014. I believe at one point he even says 2015, but backs off that, he being Mr. Taylor, the owner of appellant. So, and so if the non-breaching party continues to insist on performance by the party in default, which clearly happened here, the previous breach by the breaching party is not an excuse for non-performance by the non-breaching party, and the contract continues in full force. I really think that's
Okay, was there a demand after the $8,000 payment for gun hiding was missed? Was there a demand made to your client?
Yes, in various ways. Some of these other payments that were due under the contract, they were requested and noted. And when Mr. Meneses was notified of those, he paid those again until that the final invoice in 2013. In addition, Mr. Boone sent another demand about 2 years later in 2015. So they continued to do that, and of course sued for damages on these. And in fact, the trial court gave them credit under the contract, but as required, offset those by the damages Mr. Meneses sustained and was entitled to withhold under Texas Business and Commerce Code 28003. So,
okay. So if you're claiming that the gunite payment was not a material breach, what is the basis of that claim? That it was not a material breach? Well,
I think it's a fact question on whether a missed payment under under a contract where various payments are due. I think that's a fact question whether that's a material breach, particularly when when the work continues and then other payments are requested and made. I think it's really important that he paid when he was asked, and that was the course and dealing of the parties. That's how they did it. In fact, Mr. Robinson, who did hundreds of jobs for the appellant, said that's how they did it. And so, and that's how Mr. Meneses testified that he, that's how he knew to pay them. And so, so I think that's the importance there, Your Honor. And then of course, under 28003, Mr. Meneses was entitled to withhold payments based upon the damages, the deficiencies in the job. He's entitled to withhold up to 100%, 110% of the amount owing. The trial court found an amount much larger than that was due and owing, but did award him his damages while offsetting each amount that the appellant claimed was owed had the contract been had the appellant not breached the contract and had the appellant completed the job in a good and workmanlike manner. So I think that's important too.
You had an expert that testified that the damages were $40,000 to remedy the claims of the homeowner.
I believe that amount's right. I think it was more like 35,000.
Okay.
That the court ultimately awarded Mr. Meneses for those damages and deficiencies. And again, I think part of that is because Mr. Sullivan, the expert, did think that and testified that the palm trees, the cost of that, Mr. Meneses testified that he should get that. The court didn't ultimately put that in. So I think that's the distinction maybe between the numbers there. But I believe the amount of damages was approximately 35,000, as well as attorney's fees. Oh, excuse me. Okay. Sorry about that, Judge. Am I still here?
Yeah, you got 3 minutes.
Okay. Thank you, Your Honor. So I just wanted to, I think there's multiple ways the court can view this, and really in each of those, Mr. Meneses, the trial court correctly found and was certainly justified, and there is evidence to support the trial court's findings on this and the judgment, depending on how the court decides to look at the findings of fact issue. I think the judgment and those are both supported by the evidence that the parties, both performed under the contract, that under the law and equity, Mr. Meneses was entitled to withhold payments for these deficiencies that the trial court found exist. And I'll also note, as far as those pictures, there are a lot of pictures. There are also a number of pictures of that indicate the damages and issues and problems that Mr. Meneses testified to. So there is that, Your Honor. But the I didn't really hit on statute of frauds much, but it wasn't pled. We certainly don't think that one statement made by Mr. Boone without a ruling or anything. We did not intend to try statute of frauds by consent. Don't believe we did, and don't believe that the record reflects a basis for that. Especially as the court correctly pointed out, those amendments were never orally made. A trial amendment was not requested or made during the trial, or in fact, Mr. Boone did ask leave for the court to amend his pleadings right before trial, and that was granted, and we didn't object to that. But of course, those amended pleadings did not include statute of frauds as required by the rules. So I'm not. How much time do I have left, Your Honor?
1 minute.
Yeah.
Oh, okay. So we don't think the breach was material, even if it was. It was excused by the appellant's continued performance under the contract. We think the evidence this was a long trial. There's evidence to support each finding by the court and to support the judgment. We would respectfully ask the court to affirm the trial court's judgment in all respect. Thank you all very much for your attention to this important matter.
Thank you very much, Mr. Hall.
Thank you.
Before we go back to Mr. Boone, we have a screen that's got a clock going. So if you've got, you may just be on speaker view. If you have gallery view, you'll see the clock displayed.
Okay, thank you, Judge. And
Sure. No, that's fine.
I'm trying my best. This is the first time with the clock for me.
Sure. All right. So with that being said, Mr. Boone, you have 5 minutes for rebuttal.
Okay. Your Honor, first let me address the issue of whether or not Mr. Meneses had made claims over defects. The actual provision in the brief was several fold. He never, in writing, never put any claim by text, email, or letter. So that's what on any further claims. It's also interesting that his own expert was out there in 2013 after the completion in November, but he was out there mid 2013 doing additional work for Mr. Meneses. And this expert did not see any of these. He didn't see $40,000 worth of defects doing that. And he was working on the pool. So in 2013, which had been about the time the 1 year warranty expired, then that would have been over with. Mr. Hall references Mr. Robinson time and time again. Number one, he wasn't an expert. Mr. Robinson also testified, he goes out on the job and works. He's not part of the financial or contractual part of the operations. And Mr. Robinson testified, as opposed to the job not being complete, he made numerous trips and corrected everything to which Meneses was complaining of. I'd also like to bring out, go over a little bit on the second oral modification. And I want to distinguish for the court, our first modification is modification of the terms. This one, I didn't allege the same on this. I didn't allege the lack of consideration, because if the court believed Meneses, then we were getting a contract. So there was consideration there. So I made a different argument, and that's an issue number 10 of my trial brief. because I think they are different. Here, there would have been, by getting a contract, if the court believed it, which was disputed, but if the trial court believed it, then there would have been consideration, and that would have been in the record. However, on the payment, it was material. It's $8,800, and there was no consideration. There's not one scintilla of evidence to support the modification. Therefore, the modification is not there. It is a material breach under Dobbins versus Redden. They can't sue under the contract. And that takes care of warranty claims and a whole lot of other things. If you can't sue under the contract, you can't sue under warranty claims either. Now, as far as the legal effect of the Mustang and material breach, again, that goes to whether or not Taylor could suspend his performance. He did not. We admit that. We went on. It doesn't excuse the breach. It doesn't excuse or give Mr. Meneses rights under Dobbins to come back later and sue, but we performed. If we would have stopped, then it had to have been a material breach under Mustang, and we could have suspended performance. That's where the materiality in this comes into play with that. Lastly, I don't think the findings one way or the other affects this case, because it really comes down to the gist of once the payment was missed. He didn't make the payment. He's never made the payment. Once that was missed, and the court determined there was an agreement modifying that. It's certainly not in writing. There's nothing in writing supporting that. Then there had to be a meeting of the minds, and there's little or no evidence on that. And there's absolutely not a scintilla of evidence on consideration. And it cannot be, as cited in the brief, it cannot be, if you're going to do what you've already promised you're going to do, that's not consideration. It's got to be new consideration. So at that point, that contract's breached. He couldn't bring a claim for breach of contract under the Dobbins case. And therefore, we think the judgment should be reversed. The court did find that we had bills, contractual amounts that were due and owing. The Diamond Bride is a separate issue. Was the contract amended? Again, I argued that Diamond Bride is a good, and I argued the statute of frauds on that, that it was a good, and therefore there was no amendment in writing. Therefore, that modification likewise goes through. But I didn't argue just the oral modification in the argument to this court. Thank you. We'd ask that the judgment be reversed and judgment rendered for Taylor. Thank you.
Thank you very much, Mr. Boone. Want to let you know that your case now has been submitted by oral argument. In a second, Ms. Williamson is going to recess us. The court, after she does so, the court will be in recess until 1:30. Mrs. Williamson.
Oh, yay, oh, yay, oh, yay. The Honorable Court of Appeals for the